This is an appeal in the matter of East Riding of Yorkshire Council and KMG Strategic Land Fund.
Yes.
My ladies, my lord, I appear on behalf of the appellant. My learned friend, Mr. Lyman of King's Council, and Mr. Kaplan appear for the fund, not formally the respondent, the fund, not the sub-fund.
Yes.
As you're aware, Mr. Kaplan is attending virtually.
I do, Mr. Kaplan. I think it's we're very impressed that you're here at all.
Yes.
But you know, if you become uncomfortable, or really this has all proved a step too far, please just presume you can slip off. Even if your leader hasn't given you permission.
There are a few recent developments emanating from the respondents, of which I should make the court aware, and which I anticipate the court will not be aware of at the moment.
Right.
And the most important of those developments is that 2 days ago on Monday, those instructing me were told by the solicitors acting for the fund that the fund had been placed into liquidation by its members.
Ah, okay.
Now, we were told that that took place on the 21st of October 2024. And as the court will be aware, to put that date into some context, the liquidation took place after the hearing before Mr. Justice Richard Smith on the 4th of September 2024, but just short of 3 weeks before judgment was handed down by him on the 8th of November 2024. And given that this appears from the documents that we've seen to have been a liquidation by the members of the fund, we anticipate there must have been some advance notice of that before the 21st of October 2024 in the event.
Sorry, just give me the date it was liquidated.
It was liquidated with, I've got some documents. I
just want the date, it's fine.
The date is the 21st of October 2024.
Lovely, thank you.
So no reason's been given by the fund for the delay in informing the appellant of this fact, nor for failing to tell the judge below before the handing down of judgment.
Sorry, can I just retreat a little bit?
My lord, yes.
You're using the fund in the form that it's used in the papers.
Yes, my lord.
So when you say the members of the fund, who are you referring to that is said to have put it into liquidation?
From what I can gather from the papers, my lord, it is the shareholders in the fund.
Right.
I anticipate, I do not know, but I anticipate that those would be the shareholders in the fund who have a right to participate in the assets of the individual dedicated funds.
Sub-funds.
The sub-funds, yes.
Yeah, if we can keep it to fund and sub-funds, it's very easy.
Yes.
And what's your status in relation to the fund?
Well, it raises an interesting point now this issue has arisen, because those instructing me wrote to the solicitors acting for the fund to say, well, when did you become aware of this, and why weren't we informed?
Well, that's what I was going to
Well, that was my
take a
next
little step towards.
Could I deal with this in this way? Because I think rather than, I don't want to paraphrase what has been said when we have so little knowledge about what has actually happened.
Well, should we get the information from Mr. Lightman, perhaps?
Could I show you the documents first, Mike?
Yeah, but then could you tell us why you're telling us any of this other than for background interest?
I'm saying it's more than background interest, my lord. Should I deal with why it's relevant now?
Yes, please.
Then I'll show you the documents. The reason it's relevant is that one of the submissions that were made and accepted by Mr. Justice Richard Smith below was that the appellant had an effective remedy in the form of a petition to wind up the fund. And that was the argument that was made by my learned friends.
It certainly wasn't the only argument.
No, it certainly wasn't. But that was the point. That was one of the points on effective remedy. Now, it appears from what we've been told that the appellant was not informed of the liquidation of the fund because, as far as the fund was concerned, the appellant's shares had been cancelled. So, in fact, if that's right, it transpires the appellant could not have petitioned for the winding up of the fund
Why?
upon the dissolution of the sub-fund.
Okay, I mean, when you say that it's asserted that your shares have been cancelled, and the reason for that being?
Being the dissolution of the sub-fund, at that point they're treated as redeemed, my lord, from what we've been told.
So upon the liquidation of the sub-fund, the shares in the fund that related to the sub-fund are treated as redeemed.
As far as the fund is
Upon
told us,
liquidation.
Well, you said dissolution of the sub-fund.
I did. My
So
lord.
do you mean that the sub-fund has ceased to exist?
I did. Well,
which is different from winding up.
It is. It is. It's the sub-fund.
But how, so you are, you probably won't accept this, but is your appeal now to seek to wind up in this country a sub-fund that has ceased to exist in the place of its creation and existence?
Yes. Yes, because we've been told that it ceased to exist, so yes.
Right.
And we
when
say
you've
the
been
court
told-
has jurisdiction to do that.
When you've been told it ceased to exist, that date would be the 21st of October of last year, would it?
Well, no, my lady. We were told the sub-fund had ceased to exist in the only witness statement filed by the fund in these proceedings, which was the witness statement of Mr. Harvey, who said that at the conclusion of the liquidation of the sub-fund under the control of the directors, it had ceased to exist.
So that's
the words
it.
used. That's
All right.
it. Yes.
Okay, so is this any change to the position then that existed before the judge? I mean, you say it doesn't matter whether the thing you're seeking to wind... I'm trying to use neutral language
Yes.
here without getting drawn into anything. You say it doesn't matter that the thing that you're trying to wind up in this country has ceased to exist.
No.
And there is a series of Russian bank cases
Yes.
and the like that
Yes.
support that proposition. So if that's the case, why does any of this matter to us in terms of what we have to decide on appeal?
Because, my lord, it's relevant to ground 3 of the appeal, which is our reliance upon the exceptional jurisdiction of this
Okay.
court. Because when you look at the exercise of that exceptional jurisdiction, as the judge below did, you look at whether or not the petitioner has some form of alternative remedy, and that would include winding.
Right, but it's not relevant to ground 1 or 2.
It's relevant to ground 2 in one respect, my lord, which is that when one looks at the status of the appellant as a contingent...
It's not relevant to ground 1,
No.
and you've got to win on ground 1 to get anywhere.
Yes, my lord.
So should we start with ground 1?
My lord...
Sorry, I usurped my lady's... but
my lord,
I'm just wondering why we're starting at this
because,
place.
my lord, the way I was going, and I'm in your lordship's hands, because...
Well, actually, my ladyship's...
Sorry, I do apologise. I'm in the court.
It's fine.
I'm in
I'll assert myself when I wish to.
the way I had intended to present this appeal, and I can change course, is I intended to deal with the standing issue first of all, because the reason being that's sort of a threshold question that would be relevant to any petition when it's considered by the court. And the reason is that by dealing with that standing issue in that way, I can deal, albeit briefly, with the relevant background facts and show the court a very few documents which I say make good my point. And I think one has to have those documents in mind when one comes to consider whether or not winding up under Section 220 is. But that was my intention.
Yeah. Well, if I just make it clear, we have had an opportunity of reading in extensively.
Yes.
We've dipped into the relevant documents and obviously the authorities and respondents' notice and the authority that the respondents rely upon. So we really, we feel that this is quite narrow.
It is.
And we don't need a huge amount of background. And with respect to both of you, I conceive that this has created a lot of anxiety, this case. I mean,
Yeah.
obviously from your lay client's point of view, very, very serious for any local authority to find itself in this position. But we don't think we're going to be helped with the legal concepts and the legal issues we have to decide on in this second appeal.
Yes.
By raking over what can be regarded as, jury points.
No, and my intention, I should make it clear to your ladyship, my intention in referring to those documents was not to put before the court prejudicial material about the lack of any explanation for the disappearance.
Well, I think we can take it as read, as both judges did, that it's very disturbing.
Yes.
But that's not before us.
Well, except in one respect, I submitted his. And that is because on the issue of, you'll see how it's put in the skeleton argument, on the issue of the status of the appellant as a contingent creditor, we say, you look at those documents and you have an investment of, net investment in 55 million. You have the suspension of the fund. You have a complete dearth of any evidence to explain where that money has gone, and during the suspension you have statements emanating from the fund saying that they were realising assets and accounts showing assets.
Well, we're familiar with all of that.
And you've got that point, so I don't need to show you the documents.
We really are familiar with that. It's dealt with in detail, and we've got documents in our bundle that help us with that. If there's something specifically that you want to take us to, of course we'll look at it.
My lady, I think I can put it this way. More than anything else, I'm referring to a lack of an explanation rather than actually the explanations provided. But the reason I say that matters is because this petition was presented, we say, on the basis that we are a contingent creditor. And what will ordinarily happen on any petition where the status of the petitioner is disputed is that the respondent to the petition has to raise a substantial dispute in good faith as to the standing of the petitioner to present the petition. We say that's what has not happened in this case, and that's why the absence of an explanation in all of the documents and the one witness statement provided by Mr. Harvey is relevant, because we say if there was a good explanation for the disappearance of the money, it can be inferred it would have been provided, and it hasn't been. From that, we say, and the lack of a good explanation, we say if there is no good explanation for lost money, it is highly likely that there will be claims within the insolvency estate. The money was there, so the assets were there during this liquidation process, and then they weren't. And there's no good explanation for it. We say that's enough for this court to conclude that there is a claim likely to be within the insolvency estate.
Thank you.
And if there's a claim, that's what gets us to the status of contingent creditor, we say, because the position, as ladyships and lordship will be aware, the position in Luxembourg in this type of structure is different in that the distribution isn't made to you as a shareholder of the sub-fund or fund in that way. It's made from the pool of assets of the sub-fund, and you are a creditor of the fund with a right of recourse to that pool of assets.
Sorry, who has the right of recourse to that pool of assets?
The shareholder has the right of recourse to that pool of assets, but as a creditor, not a shareholder.
Okay, that's something you will need to go over. What right, I mean, I understand that you as a shareholder of the fund have a relationship, a contract, let's say a contractual relationship with the fund by reason of your status as a shareholder. What right, direct right of recourse do you have to the assets?
Well, the articles of the fund and the sub-fund provide that the right of recourse of those holding shares is limited to the assets within the dedicated.
Whose right of recourse?
The shareholders' right.
You say the shareholders' direct. I mean, okay, we'll need to look at that. I mean, is it not that the company can only have recourse? Sorry, the fund. Let's call it. Sorry, the fund can only have recourse to the assets.
No, my lord.
So what is the nature of your quote right of recourse? What liability are you satisfying, and how does it happen?
The way it works, as we understand it from the expert evidence, my lord, is the right of recourse is of the shareholder under the articles to the pool of assets in the dedicated fund.
So that's,
and that right is not. I apologise for interrupting.
Sorry, no.
I
interrupted you. Sorry.
That right of recourse is not by reason of status as shareholder. It's because when there is a surplus in the liquidation, you are a creditor, and that's why we say you're a contingent creditor of the sub-fund. So you're not receiving in the ordinary situation in a liquidation of an English company. It's very different. You satisfy the creditor's claims, and then there's a distribution to the shareholders further down the line if there's anything left over. Here, I think the order of priorities is the same. But at the point there's a surplus after creditors' claims have been satisfied, at that point you become a creditor entitled to your share of what's left in the sub-fund.
Okay. I mean, it may not. I mean, this. I don't want to disappear down a rabbit hole here. When in the UK, in England anyway, in England and Wales, I should say, when a company is wound up, what happens is that the persons who are creditors and shareholders have rights under the statutory scheme to a distribution by the liquidator of the assets of the company to pay first the creditors and then to make a distribution of any surplus to the shareholders.
Yes.
The rights of the creditors and shareholders are under the statutory scheme and are enforceable as the objects of the statutory scheme. What they don't get is a direct right of action, recourse, call it what you will, to the assets. Yes. And I'm just trying to understand, if it matters at the moment, and maybe we can move on, but when we come back to it, what the actual mechanism you're saying is. Because when you say right of recourse, you're not actually suggesting, I think, that your clients have any direct claim over the assets. What you have is a right to receive some payment, put neutrally, by whoever is conducting the winding up of the fund from the assets held in the sub-fund.
That is right, my lord, yes.
Right.
That is right. It differs in this respect. Now, I'll take your lordship in a moment to the expert evidence, but it differs in this respect in that you wouldn't say that a shareholder entitled to a distribution of the surplus in an English liquidation is a creditor of the company, whereas we say that's how it works in Luxembourg,
right.
And that's what the expert evidence was. So that's an important point of difference, because what the petitioner was seeking to do in this case was, in a sense, the path of course least disturbance, which was to petition according to its rights to participate in the sub-fund, rather than petition the fund, which may or may not have numerous other sub-funds which are solvent and properly traded. So that's why the approach was taken that it was, and it was taken because of what the articles provide in terms of that.
Right. So, but okay, well, maybe we can park it after this, but so you say that your status is that of contingent creditor only after what in the Luxembourg
this
situation?
is the point, my lord. because I can only claim status as creditor when there is a recovery into, if I can call it the estate, using the broadest possible word, under the control of the liquidators who are performing this exercise, I can only claim to be a creditor when there is a surplus available for that purpose. And the only basis upon which we contend there might be a surplus for that purpose is that the fund is likely, we say more likely than not, to have claims against third parties, against its management, against its advisors, in respect to the disappearance of the money.
Yeah, and you say presumably this is really in essence an investment vehicle such that it doesn't incur trade creditors or relatively few trade creditors in the normal way, so that the likelihood is, you'd say, that there would be a surplus available for distribution.
You're quite right, Matt, but I can actually do better than that, because in this case, the notice to shareholders upon the conclusion of the liquidation was that the fund, insofar as there were any creditors left over of the sub-fund, the fund had paid those creditors off. So
well, they did it by way of a loan and then forgiveness.
Yes, exactly. So it was. You're quite right.
Yeah.
But the effect is, so there's nothing. So we say any recovery into the sub-fund, into the estate, will result in distribution to us.
Okay.
And you rely for your contingency, if you like, the fact that there is likely to be successful litigation.
Yes.
Relating to the loss of the funds in the sub-fund.
Yes, I
loss
do.
of the asset, subject, don't say use funds in the wrong way, but loss of the money. Let's call it the money.
Yes.
the investments in the sub-fund.
And we get there really by the route that, simple inference, if there was a good explanation for the loss of this money, it would have been provided, and it never has. Now, I appreciate that it might be said, well, I think in fairness, Mr. Lightman does say this. He says, well, you haven't told us who your targets are for that litigation, you haven't addressed the prospects of recovery, you haven't told us what your causes of action are, and I quite accept all of that.
It's all feeling a bit optimistic.
Well, my lady, all I would say is this, is that you have the money, it really is a situation where you have an evidential vacuum. You have the money having disappeared, and you have no adequate explanation for it. Now, I say if there was a good explanation, it would have been provided. We can't go beyond that, because we have no knowledge as to what has happened. The liquidation that took place under the control of the directors. It wasn't as we would understand it here, an investigation of any sorts. So we have brought to court the best evidence that we can bring, and we've been met with, if not silence, as good as from the respondent. That's the. I appreciate, and I'm aware of. I'm aware of the fact that I'm really making. It's almost a point that might be taken against a director in a breach of fiduciary duty case. The money's gone. Where is it? If you can't explain where it's gone, then you're liable. I appreciate this is a more difficult and more complicated situation, because we really have no visibility at all in terms of what's happened. But we say we have enough on the balance of probabilities to say that we have a claim, and that's the basis of the contingent credit.
Is your ground 2 critical to get to your ground 3?
No, it's not, my lord.
So, in a sense, I mean, if you, as I understand it, if your ground 1 is key, because unless you've got something which is capable of being the object of an English winding up, you don't progress further.
No.
If you do have that, then I think your ground 3 suggests that there are exceptional cases where the English court could say there is something here which exceptionally requires investigation
Yes.
at the behest of somebody who may be a beneficiary of the winding up process, whether it be by way of being a creditor or a shareholder.
Yes.
But this is something that exceptionally needs investigation. So in a sense, your ground two, as I understand your argument, Mr. Lightman, I think may disagree, but your ground two is not an essential stepping stone to ground three. You don't have to win. The one ground you do have to win on is ground one.
I realise that. How do you wish me to proceed? Would you like me
Ground
to...
one.
Ground one. I will take that.
Please. I mean, there's a reason you put it as your first ground.
There is. No, I realise that. Just
although for my part, I should say, Mr. Lewis, I found it very useful to have a better understanding of how to put your case on contingent creditors. So your time has not been wasted at all. I found it very helpful.
And a lot of what I've said to your Ladyship and your Lordship about contingent creditor status, that does feed into the exceptionality, we say, of the circumstances of this case. So I needn't repeat those in due course, but that's an important point. So, in fact, we say by the time of this second appeal, this is actually quite a narrow point at this stage, because what the appellant has to do is it has to, well, first of all, legally, we say actually the question before the courts below and before this court is actually very simple. One need not look further than the International Tin Council case and the test that was set out in that. And that test is simply this. Are you a company or association, first of all? And we say, as we said below, we say at the very least the sub-fund is an association, taking into account the breadth of entities which that encompasses. Secondly, is the sub-fund an association carried out for profit? Because if it's not, it's a club and it can't be wound up. Obviously it is. And thirdly, is it a thing, an entity, of the sort that Parliament would have wished to be wound up under Section 221?
Right, can I just pause with those
Yes.
three questions?
Yes.
You started off by saying, at very least, the sub-fund is an association. What
Well, I say that.
do you say the sub-fund is an association?
I do.
Right.
I do, my lord.
So, can we ignore the words at very least?
We can, my lord.
Right. And then secondly, sorry, in your third thing, you say, is it a thing or an entity? Do you need to say it's a thing or an
No, I
entity?
say, is it an association which Parliament would have intended to be wound up under Section 221?
Right. So, 1, it's an association. 2, carried on with a view to profit. 3, is it an association Parliament would have intended to be wound up?
And it's that third issue,
Right.
on which the petitioner has been unsuccessful so far. Whether it's an association of the sort that Parliament would have intended to be wound up under the Act. And obviously, I'm not on this appeal re-arguing all of the factors that were put before the courts below, that we say are indicia of the fact that this was such an association that was intended by Parliament to be wound up. I accept, of course, we have to identify errors of principle in the judge's approach to that issue. And we say, very simply, there are really three issues.
Well, you just have to. Why do you say it was a principle? He's either right or he's wrong.
Yeah,
It's not a question of discretion at this stage. This is a raw jurisdictional question.
It is, my lord. Yes.
So he's either right or he's wrong.
He's right or he's wrong about that. The most important issue upon which we rely is the fact that the sub-fund is an entity that is capable of being wound up under the law of Luxembourg. That is, we say that's critical. And under the law of Luxembourg, it's common ground. The sub-fund could be wound up by the court as part of a judicial liquidation, or voluntarily, as actually happened in this case.
But could be wound up as what? I mean, if you're saying it could be wound up as an association under the law of Luxembourg, then you'd say, why shouldn't English law treat it as an association? But do we know why Luxembourg law says it can be wound up?
No, we don't, my lord, but we know...
Because Luxembourg could have a special law of winding up of sub-funds, and that wouldn't help us, would it?
But that's not something to which any of the experts have referred, save for the availability of judicial liquidation, which was said to apply to the sub-fund.
Yeah, but so I'm not... You're saying it's very important that Luxembourg recognises this is something that can be wound up under the law of Luxembourg.
Yes.
But that's not... Why is that of any real relevance to us when we have to answer the question, is it an association which the UK Parliament would have wished to be wound up under English law?
No, I accept, my lord, the difference in the question. I think the point that we make is simply this. If a liquidator were appointed in respect of a winding up in Luxembourg, we would expect the court here to recognise that winding up and to accept the status of a liquidator in the winding. Now, if that's the case,
under what regime?
I think it would be under the cross-border insolvency regulations.
And do the cross-border insolvency regulations apply to what? Companies?
They apply to companies, yes. Now, but I think, my lord, can I put my case in this way? I say it doesn't matter what the sub-fund is as a matter of Luxembourg law. All that matters is it can be wound up. The question for this court is whether the sub-fund is a company or association for the purposes of section 220, and that is an English law question.
Yeah, which is why I started questioning it, given it's an English law question, why we get much assistance from what the Luxembourg law thinks it can do in relation to this sub-fund.
I think the answer to that, my lord, is probably practical, which is that points taken below in both courts were that what's the point in appointing a liquidator of the sub-fund in circumstances where...
But that's a discretionary, that would go to discretion, not jurisdiction.
It would.
And we're here dealing with jurisdiction, aren't we?
We are, my lord, yes. I think the short point we make is it is an association. When you're deciding whether or not there's jurisdiction under section 220, it's relevant to look at what the court in Luxembourg will do, whether it is capable of being wound up under its local law. And if it's capable of being wound up under its local law, we say that that's something that this court should recognise and should adopt the same approach. And the judge, I should say, the judge below accepted the relevance of those points, but we say that his error was that he didn't attach sufficient weight to them.
See, that's the problem. If this is a raw jurisdictional question as a matter of English law, I find it difficult to understand how questions of whether the judge gave enough weight to the position in Luxembourg really can take us very far.
It's because, my lord, it's not. I fully appreciate it's not the exercise of discretion, but what the judge was doing was he was performing the exercise of weighing up these different factors.
I entirely accept that if there was jurisdiction to wind it up here, a relevant factor in the exercise of the court's discretion as to whether to apply that English remedy of winding up here to the foreign thing is an exercise of discretion, and one of the relevant factors would undoubtedly be, is it something capable of being wound up in its own jurisdiction, and would what we do be recognised there? Those are all the sort of things that Lord Collins said in Drax, would feed into a discretion. But I'm struggling at the moment to understand why it's relevant to the hard-edged jurisdictional question.
Because I think... Sorry.
Yeah, help me on this, because obviously this isn't my area, but when I was reading the skeletons and the judgment, I thought that you were arguing that the relevance of the ability to wind up in Luxembourg, this particular sub-fund, was to feed in to whether or not this was the type of association which Parliament would have anticipated and have wished to be.
That's what I argued.
And so in the jurisdictional point, in deciding whether this was something that our Parliament would have anticipated and wished to be able to be wound up, they would say we would wish to be able to have comity with other countries that would allow this type of association to be wound up. Now, if I've got that completely wrong, and it only comes in at the discretionary level, please, I'm not...
My lady's got it right. And if I may say so, your lordship has it right as well, in the sense
well done us.
in the sense that my point was jurisdictional, and the reason that this issue came up is that the approach that the courts adopted, applying the approach in international tin councils, you look at the characteristics of the thing we're seeking to wind up, and looking at those characteristics, does that bring it within section 220? A relevant characteristic we submitted was the fact that it was capable of being.
I understand.
And I can show if I can just show the court very briefly from the judgment how that issue is dealt with, because as I say, we say that there are 3 points on section 220, but this is the point upon which we place the most reliance. It's at divider 9 of the Corba. You'll see where it's dealt with. It's on page 80 of the core bundle. The court has that.
Sorry. Sorry, ITC tab 5.
I apologise, but no, it's the core bundle.
Sorry, in the core bundle. Sorry, I'm so sorry.
Judgment of Mr. Justice Richard Smith.
Sorry, sir.
So, this is the only part of the judgment where this issue is dealt with. It's paragraphs 57 and 58. And at 57, the judge addresses the availability of voluntary. And he says, as such, I also agree this does appear to advance the analysis of whether the sub-fund is an entity falling within the scope of section 220.
I wonder, I'm sorry to interrupt, I think there might be a typo there, and the word should be not.
Yeah. Sorry,
In the last sentence of paragraph 57.
I think that may be right, but
does not appear to advance the analysis.
I think that may be right. So that deals with voluntary. So he refers to it, but he doesn't take it any further than that. He just says it doesn't advance the analysis. And the point that we make is it does, because the fact it can be wound up is relevant to whether or not it's an entity under section 220. More importantly, under paragraph 58.
So we should be able, is it agreed that it does, the word not should be inserted?
I think that must be right. I think the previous sentence must not have been picked up on corrections, my lord.
Yeah, I mean, we could check that because presumably he's talking about I also agree, so presumably the judge must have made an observation.
Yes, no, I think that's the only way that could be done.
Yeah.
So we say he doesn't give enough emphasis to that point. And then paragraph 58, perhaps more importantly, because it deals with judicial winding. At the end of paragraph 58, however, I also agree that the availability of judicial liquidation in Luxembourg in these circumstances sheds little light on whether it should be amenable to being wound up under section 220. And the point we make is this, that conflates two different things. There's the circumstances in which the sub-fund can be liquidated in Luxembourg, and we accept that the circumstances in which a judicial liquidation takes place are limited. But our point was not that. Our point was, if it's capable of being wound up by the court, it should be capable of being wound up by the English court as well.
While we've got the judgment open,
Yes.
could you help me? I didn't want to interrupt your flow, but when we were looking at the components, is it an association, is it profit, and is it something Parliament would have anticipated? I think your submission was that you only lost on the third of those.
Yes.
But I just wanted to go back to paragraph 65 of the judgment, because my reading of that, please put me right. My reading of that was that the judge found against you on numbers 1 and 3 that it wasn't an association, but in any event, it wasn't an entity Parliament reasonably intended to be wound up. We look at 65. My view, the judge's analysis, it explains about how the original concession was withdrawn perfectly properly. And then it goes on, the judge's analysis, so that's the first instance judge, reveals the sub-fund was neither, even on the broad terms, so neither a company nor an association. And then the appellant submissions go to the characteristics, which you've highlighted for us in your skeleton argument. Having done so, it's clear to me as to the judge that in substance sub-portfolio of assets, etc. Now, my reading of that was that the judge was agreeing with the judge at first instance that this was not an association.
And to take up my lady's point further, if you go to paragraph page 102 and 107 of the bundle, which is the first instance judgment, it's quite clear in the first instance that Miss Hilliard was not arguing that it was a company or an association, and the conclusion of the judge at paragraph 38 was, in conclusion, as the sub-fund is neither an unregistered company in accordance with its natural meaning, nor a company, nor an association, it doesn't fall within 220 and cannot be wound up by the court. Yeah.
So just so I'm clear, so you can help us with it, Mr. Lewis, from my reading of the judgment, I think you have to tackle whether it's an association at all, not just whether it's something that Parliament would wish to be part of the
Yes,
an entity Parliament reasonably intended to be wound up as an unregistered company.
Yes.
Now, I think you would say, well, my Luxembourg point helps me on that too.
I think the issue here in part is because the judge below very fairly dealt with if I can put it this way, the characteristics point. That you look at all the characteristics and then see if it falls within section 220, and then dealt with the question of whether or not it was an association or company for the purposes, strictly speaking, for the purposes of section 220. I think the issue there is that when you look at whether or not it's an association for the purposes of section 220, that kind of deals with both questions in a way simultaneously, which is whether or not it is an association at all, and whether or not it's an association which Parliament would have intended to be wound up. And we certainly cited the authorities in relation to associations, including there in the bundle, the authorities say how broad a meaning association has.
I understand that, because at first instance it had been conceded.
It had.
But then on appeal it was argued. Can I just be clear for my purposes, for this second appeal, on behalf of the appellant, do you accept that the appeal judge found that there was no association. It found against you on your argument of association, by reference in particular to the paragraphs that both myself and my Lord Justice Snowden have referred you to.
I think, my lady, I do.
Thank you, that's
I do accept that, because I think that follows from what's said in the middle of paragraph 65. But
I'm not saying that holds you below the waterline. I'm
No.
just simply saying
No,
what it does is help us to put your arguments on
Yes.
section 220 in its overall picture.
No, it's helpful, my lady. Thank you. I think the point that we make here, when it comes to association, is the breadth of that term as it applies. And we've referred to the authorities in the skeleton arguments.
Yes, you have.
of that issue. And I can take you to them, but we have, from the St James's Club cases onwards, they all say how broad the term is. So I think you start from the position, is it an association, which is not a high threshold to cross. And of course that then becomes different when one looks at whether it's an association within the intentions part.
Yep.
That's the real issue.
Can you help me? Does the association have to? What's the connection that has to exist between the people who constitute the association and the property or assets of the association? Because in a sense, suppose you just have a WhatsApp group. Are you saying that the English court could wind up a WhatsApp group?
No.
And why not? That's an association of people.
Let's assume it's carried on with a view to profit. My lord, it wouldn't work, because there is nothing to be wound up in terms of assets. Nothing in the insolvency state.
Right.
The difference, my lord, here is that just as with an unincorporated association, the assets of the unincorporated association may be held by individual members, by trustees. And here it just so happens that it's the fund that holds the assets for the sub-fund.
Well, this is why I wanted to get into the area of recourse and the like, because what would be wrong with the following analysis, if anything? I'll put it to you. You have a relationship with the fund in which you are a shareholder, and that relationship is constituted by the terms of the constitution and the terms of the shares. You have no direct claim to own or to have recourse to the assets in the sub-fund. Your rights are solely against the fund, which you could seek to have wound up as a creditor or as a shareholder, but not, the association does not exist by reference to the assets in the sub-fund. There's a different, and I'll just, while you're thinking about it, and it may be a question you want to take a moment to think about or come back to, but you mentioned, for example, a club or an association where the assets are held on the contract holding theory, I think is the expression that is usually used, by the officers of the association for the time being on behalf of the members, where there's a direct relationship between the members of the association and the assets, which would be the thing that you wind up. Here, I'm struggling at the moment to make that connection with the assets which are held in the sub-fund, and I for one, would like some help with making that connection.
I think the best way for me to do that is to take you to the articles themselves and show, because your lordship said quite correctly, as actually almost with any liquidation, the right of recourse of a creditor isn't direct against the assets. There's an insolvency estate, and it's applied. And that, we say, is precisely what happens here. limited to the assets within the sub-fund of the Articles of Association.
Well, if you're winding up the fund, I think what will be said against you is if you're winding up the fund, you would be right. You'd be winding up the fund in which you are a shareholder and which you might become a creditor entitled to a distribution, but with the liquidator's right of recourse is only against the sub-fund. i.e. it's the liquidator, in order to satisfy your claims, whatever they are, however you characterise them, the liquidator could only have recourse to the assets in the sub-fund. But that's in a winding up of the fund, not the sub-fund. And that's the disconnect I'm struggling with, speaking in time for myself, the disconnect I'm struggling with at the moment, which might differentiate the position we have here with, for example, the winding up of a club or an actual company.
Yes. Perhaps the best way for me to address that, my Lord, is by reference to the Articles of Association.
Because it does go to the question my lady put to you directly, which is, in a sense, is this an association within the meaning which English law gives both to that word in this context of something which you would expect the English court to be capable of winding up? Differentiate it from the WhatsApp group in my rather silly example.
So if we could, with the articles, in fact, I think the best way of showing the court this may be by reference to the judgment of below, because in fact the judge referred to all of the articles, I think, that we referred to.
As a matter of fact, the judge below encompassed a great deal more detail of fact and evidence in her judgment than did that of Mr. Justice Richard Smith.
Yes. Yes. I think that was partly because of the way it was put below, which was an expansive interpretation of section 220. Whereas we focused on the association group, but the judge below dealt with all of the characters.
She did.
You're quite right.
Yes. She begins at paragraph 23 under the heading "The Articles, the Offering Document and Expert Evidence." And the article she picks up at page 97 at paragraph 25.
Yes, I'm grateful, my lady.
So which are the articles that you specifically want to take us to? Would it be Article 16?
Article 6, first of all, please, my lady.
Thank you.
It was 16.
Yes, that's what
particular reliance was placed on, wasn't it?
And C, I think, as well, my
Right.
lady. For each dedicated fund, a separate portfolio of investments and assets will be maintained. Different portfolios will be separately invested in accordance with specific features described in the offering document. Company. Mm-hmm. 8.3. Shareholders may request redemption of their shares in accordance with the conditions set forth for each dedicated fund in the offering document. 16G, dedicate in the event that for whatever any reason whatsoever, the value of assets of the dedicated fund should fall down to such an amount considered by the Board of Directors the minimum level under which a dedicated fund may no longer operate in an economically efficient way, or in the event of a significant change in the economic or political situation impacting such dedication negative consequences. So, the Board of Directors may decide to conduct a liquidation. The company should send notice to shareholders of relevant dedicated fund before the effective date of such liquidation.
How does that tie in with your submissions?
My lady, the point that we make is that we accept that the appellant is a shareholder of the fund, but we say under the relevant provisions of the articles, the rights of recourse as a shareholder in the fund are to the assets of the sub-fund, and that
By virtue of article, which bit of which article?
I'm just trying to, if you bear with me for one moment.
Of course.
Could I take you to my skeleton arm? Of course. I think I've got the references there. I've put the references in there upon which we place particular rights. So
That's helpful,
that might be the best place to go. So this is at page 20 of the core bundle.
20, sorry, yes.
Yes.
And what paragraph have you?
It's paragraph 10 onwards. So the court be aware there's the offering document and there's
Yes.
the articles.
Yes.
And what one sees actually in terms of how the fund describes the investment of the appellant and other shareholders to those shareholders is as if they are shareholders of the sub-fund. That's how it's described.
Yeah, but okay, so this is difficult enough under English law, never mind Luxembourg law. Do you construe the Articles of Association by reference to the offering document or not?
I think the offering document is the basis. I mean, this entity has existence by reason of its Articles of Association, also the basis upon which the investors invest.
Right.
So we say the offering document is relevant to the investors' investment.
Okay, because the offering document isn't quite in the same terms as the Articles of Association.
They're not.
And for example, the offering document talks about shares in each dedicated fund.
Yes.
Section 3, you see that at page 96. You keep a finger in. It's the thing you quote in your skeleton. If you keep a finger in page 96 and page 20, you can see that section 3 says, in accordance with the Articles of Association, the Board of Directors of the fund may issue shares in each dedicated fund. That's not actually what they do at all, as far as I understand it. As I understand it, the capital of the company is represented by fully or partly paid up shares of no par capital in the company, i.e. the fund, albeit that the shares relate in some way to the sub-fund. You know, I mean, in English law terms, I'd think about it that you would issue Class A shares, Class B shares, Class C shares, giving rights of distribution
Limited to
surplus
certain,
arising in
yes.
the sub-fund. But I don't understand at all the concept of a sub-fund issuing shares in itself. And I don't think that's actually what happens.
From the articles, my lord, it's not what happened, but the rights that attach to those shares are specific to the sub-fund. And the sub-fund, one looks at the...
Yeah, but you're not, so you see, you're not actually saying that the shareholder is a shareholder in the sub-fund.
No, my lord, I'm not. And I've never said that.
Although that is the reference that you picked out in your skeleton at paragraph 20, and I'm just clarifying that's not what you're actually saying.
No, that's how this investment was sold to investors. I accept that's not correct as a representation based on the articles. The shares themselves, the actual subscriptions at page 203, of the supplementary bundle. And one can see how the shares are described, which is they're described as shares in KMG SICAV-SIF-Lucent Strategic Land Fund Class C GBP. And under the offering document,
So if you give us that reference again.
it's page 203
Of the supplementary.
yes, that's the large bundle.
Yeah, sorry, 203 is just a trade note. It's just a trade. That's just a trade ticket.
Yes. But recording what it is, that's what the investment is.
Okay, so Class C.
Class C. And then if your lordship were to turn to the offering document, starts at divider 20, the previous divider. This is the offering document for this particular fund, starts at page 189. And you'll see there's the usual description of what it is that's being invested in and what's intended. There'll be valuations on page 191 of the net asset value, but if one goes on, the description of the investment characteristic starts on page 196, and so 197, then you have the classes of shares. So I think your lordship is right. I think the way it works is that I accept you're a shareholder in the fund. I accept that. You are a class of shareholder in the fund, and as such, your rights of recourse are limited to the sub-fund.
Yeah. I'm not being difficult with you.
But
you're, this is a very confusing document, not least because if you go to the definitions at page 173, shares are defined as each share within any dedicated fund. So there's quite a lot of
my lord, this is
ambiguity, shall we say?
There is, and there is also in the communications from the fund to the shareholders. You've seen that in the bundle the notices. They're notices to shareholders of the dedicated fund. So there is ambiguity, but I think formally accepting the position that the appellant is a shareholder in the fund, but with a right of recourse to the assets within the dedicated fund, we say that does not constrain, that does not prevent us from seeking winding up on the basis of an association for the purposes of the Act.
Like a dog gnawing at an old bone, I will pick you up on when you say we're a shareholder in the fund with a right of recourse too. I'm going to keep coming back to the question of who has the right of recourse.
Yes.
I fully understand that the company can only have a right of recourse to the sub-fund in order to, for example, pay distributions on its C shares. And I fully understand that the liquidator may only have a right of recourse to the sub-fund to pay any surplus arising on a liquidation of the sub-fund to the holders of the C shares. What I'm struggling with at the moment is whether you as a C shareholder have a direct right of recourse against the sub-fund, and if so, what is that?
My lord, there was a reference and I was struggling to find it. I think I've actually got there.
Excellent.
Could I ask your lordship to turn, ask the court to turn, it's the supplemental appeal bundle. It's the articles for incorporation appear under divider 22.
Yeah.
And at page 207, Article 6 deals with the shares.
See, I keep going back to Article 6D.
My lord, that's exactly where I was going to take the leadership.
There we are, I've landed on the right spot.
You got there fast enough. Thank you. The company is one single entity, however, the rights of investors and creditors regarding a dedicated fund or raised by the constitution, operation or liquidation of a dedicated fund are limited to the assets of this dedicated fund. and the assets of the dedicated fund will be answerable exclusively for the rights of the shareholders relating to the dedicated fund, and for those of the creditors whose claim arose in relation to the constitution, operation, and liquidation of dedicated funds. So what that appears to do is to recognise a direct right of recourse of a shareholder or creditor against the assets of the dedicated fund.
Really?
Well, yes, that's what we say it says.
If you have a direct right of recourse to the
Sorry,
if you have
I apologise. That was an imprecise way of expressing what I intended. I don't mean we have any beneficial interest in the assets of the sub-fund and we can simply take. I don't.
Yeah, because if you did, then my next question, and I suspect you saw the elephant trap opening before you,
yes.
which is why do you need a winding up order?
Well, quite so, and that's why this situation. I mean, just as you wouldn't if you're a shareholder of an English company have that beneficial interest in the assets. It's exactly the same in that respect. But your Lordship's question to me was, well, isn't it the fund's right of recourse to the sub-fund? And that's not what the Articles of Incorporation appear to suggest.
Well, I mean, it's neutral, isn't it? I mean, it talks about the assets of a dedicated fund will be answerable exclusively for the rights of the shareholders. Well, the shareholders we know are the shareholders in the fund. And so why do you not read that as saying that whoever is administering the fund vis-à-vis its shareholders, whether it's the directors or a liquidator of the fund, can only have recourse to the assets in the dedicated fund to satisfy whatever rights that the shareholders of the fund have. That's the disconnect that's the sort of structural disconnect, cut out, call it what you will, that I'm struggling with. The argument against you is you're aiming at the wrong target. You should be seeking to wind up the fund as a shareholder of the fund. And that's what the structure envisages. And the liquidator of the fund would then only have recourse to the sub-fund to satisfy your rights as a C shareholder in the fund. But what you can't do is claim either personally to go directly against the assets of the sub-fund or even get a collective remedy of winding up in relation to the assets of the sub-fund. That's how I see this, the battle lines in this case. I'm not saying which way is right or wrong at the moment, but that seems to me the argument that divides Mr. Lightman and yourself.
Yes, my lord, that's right. I think the answer to that is that one looks at the substance and not the form here in terms of what's going on. And the fact is that the appointment of a liquidator over the sub-fund, that liquidator would have rights to collect in assets. It would be able to do that. It would have rights of claim as well. And it would be able to investigate. Now, it might be that what the liquidator would lack is the fund as the entity which holds the assets. But we know that there are no assets of the fund. So we say it doesn't really arise. As a matter of practicality, one can see the sub-fund as a separate thing, as an association of its investors, and wind it up on that basis.
Okay, thank you. Now, where do we go from there?
I think, my lady, there were two other. We've addressed them in our skeleton argument, and I'll be quite frank. Of the points that we make on section 220 and any error of principle by the judge below,
Yes.
We identify three,
Yep.
and I have already given you, if you like, the most important of those 3
Yes.
points, and you'll see what the other points are. I think
you, as you've very frankly told us, your emphasis is on the fact that this could be done in Luxembourg.
yes,
And that's the
Yes, it is.
that's you say
It is.
that's what unlocks Section 220.
It is, yes. And when one looks, I mean, if one has to look at the practicalities of what a liquidator could do in this, we say that they would have all the rights of action personally that a liquidator has to get in the assets. And so it would be a liquidation with a certain purpose. Milady, I think that deals with how we put Section 220.
So that's round one.
That's round one. I think I've dealt with the contingent creditor.
I was going to say, I think. Well, I mean, you said at the beginning you wanted to deal with status first, so I think we've dealt. You did ground two first, didn't you?
I did, and then that just leads us, I think, to the
Exceptionality.
Point.
Certainly. Which you've been helpfully emphasised is not dependent upon ground two.
No.
That effectively they're an alternative.
Yes, and I think the important thing for the court to keep in mind when one looks at the exceptionality is that this is not a creditor's petition in the sense of a petition based upon the inability of the sub-fund to pay its debts. That was actually an original ground of the petition, but it was deleted by amendment. The ground that's relied upon here is Section 221(5)(a). And we say, relying on that section, we have sufficient standing, sufficient interest for the purposes of winding up. And one can see why a different standing question arises, for example, on a creditor's petition compared to a petition relying upon dissolution, cessation of trading or liquidation, because you're dealing with two very different situations. In the latter situation, we say we have a sufficient interest, even if that's not formally a creditor status under ground two. There are really, I think, 2 points to be made there as to status as creditor not being determinative of our standing to petition. The first is to adopt the words of Mr. Justice Bennett in the Russian English Bank case. There's no possible harm that can be done to anybody by the winding up order that is sought. On any view on the respondent's own evidence, fund's own evidence, there is no trading business that might be harmed by the appointment of liquidators to investigate and bring claims. And in fact, by directing our petition as we have to the sub-fund rather than the fund, we've actually intentionally sought to do cause the least amount of disruption to those other investors in those other sub-funds. And the second point, the reason why the threshold test for an ordinary creditor's petition would obviously be higher is that where the petition is based upon the insolvency of the entity, it makes perfect sense that there be a strict approach to prove standing as a creditor on the balance of probabilities. But where solvency is not the issue, we say the exceptional jurisdiction exists even if you can't prove on the balance of probabilities. Now that, I think, that's the first point. The second point is about the lack of alternative remedies. And as the judge said, paragraph 82 of judgment, he said there was scant evidence before me concerning the adequacy of alternative remedies. We say that scant evidence is actually because there was no real practical alternative remedy available to the petitioner. First, in respect of regulatory action, and this was canvassed in all the submissions, the judge was shown a letter that was addressed to the Luxembourg Commission, the supervisory sector. That appears in the supplemental bundle at page 332, and there was no response in relation to that. In addition, Mr. Mudd, who appeared on the appeal for Mr. Justice Michael Green, he told the court that the sub-fund had been looked at by the regulator and there had been a thorough investigation. We know that nothing has come of that. And in
Was there any sort of a report, or
sorry?
was there any sort of a report?
Made to prompt that investigation?
No, sorry. You're saying you'd been told, or Mr. Green said, that there'd been a thorough investigation by the regulatory body in Luxembourg and nothing was amiss. And I just wondered whether they'd committed that view to writing.
No, there was nothing. It was the judgment of Mr. Michael Green, Mr. Justice Michael Green, is at divider 8. And
Page 50, I think.
and this point is addressed, it's paragraphs 8 through to 11, what was said by Mr. Mudd in particular in paragraph 9. He says at the end of paragraph 9, furthermore, they have explained what has happened to the investors, and indeed, he says, the Luxembourg regulators conducted a 2-year investigation, and apart from one aspect to do with evaluation, they found nothing wrong.
Nothing much wrong.
Nothing much wrong. And you'll see what I said in response to that. We haven't been told anything about that, and that prompted the comment in paragraph 11. Obviously, the judge couldn't decide that, but Mr. Mudd or anyone else representing the respondent could put in evidence to such effect and seek to demonstrate it, and they've chosen not to.
Yep.
That's what we say about regulatory action. Secondly, as to the winding up of the fund, there wasn't actually any evidence before the court that that was a possible route for the petitioner in this case. There's no expert evidence addressing that. And it was argued by the fund that at the hearing before Mr. Justice Michael Green, that was the appropriate course, but that wasn't dealt with in the evidence. In fact, it now appears that a liquidation of the fund would have done nothing to assist. And I think at that point, the respondents produced an additional bundle, and if I may, I think it's the final document I need to take the court to. Can I show you very briefly the correspondence relating to the liquidation of the fund, because I think it provides some important context. The court won't have those bundles because I understand from my friend the respondent filed them electronically.
Further supplementary bundle?
Oh,
no, that's authority.
there is my lady, there was some communication. I don't know whether that led to it being printed. We have printed copies of the supplemental bundle.
Oh, thank you.
So, this is quite a short point, I'll do it quite briefly. If I could ask the court to turn to divider 3. So this is the letter we received on Monday from the solicitors acting for the fund. And you'll see we write in advance of the hearing of your client's appeal in the Court of Appeal, which is due to take place on Wednesday, and with a view to ensuring that you are aware of the current status of KMG SICAV-SIF, the fund. They say, on 21st of October, an extraordinary general meeting of its then shareholders voted in favour of the liquidation of the fund and the appointment of liquidators. And at 2, the fund shareholders were informed of the liquidation by the liquidator on the 15th of November. And they say, for the avoidance of doubt, they remain instructed for the purpose of the appeal by the liquidator on behalf of the fund. The resolution, the minutes of the extraordinary general meeting are at page 14. That they do really no more than record the resolution to dissolve. And, well, page 16. First resolution, the meeting resolves to dissolve and put into liquidation the fund as from 21st of October 2024. And then, if I could ask the court to turn to page 27, to show the court the explanation provided by the fund for all of this. This is a letter from my instructing solicitors. You'll see they raise the issue of a late notification of the liquidation of the fund. The fact they may have wished to liaise with the liquidator on issues which will assist the court. And then paragraph 4, please can you confirm the date which your firm was informed of the liquidation when you were instructed by the liquidator? And at 5, at paragraph 2 of your letter, you say that the fund's shareholders were informed of the liquidation by the liquidator on the 15th of November 2024. Our client has no record of being informed by the liquidator of the liquidation. Please can you confirm why our client was not informed by the liquidator of the liquidation? And the answer is very brief. It's on page 28. As to first question, when they were informed of the liquidation, they say that's privileged. And as to paragraph 5, they say we're instructed that your client's shareholding in the fund was considered redeemed when the sub-fund was closed prior to the liquidation of the fund. Accordingly, it was not notified of the EGM or the result of the EGM liquidation. So, I mean, from the limited amount that we know, it appears that the appellant's being treated no longer as a shareholder by reason of dissolution of the sub-fund. So the idea that there was some alternative remedy by way of winding up of the fund, that does not provide any answer.
It's a question I suspect from Mr. Lightman, but I'll ask you it simply so he hears it, and in case you have an answer. What does considered redeemed mean? Considered by whom? And how do you have how are shares redeemed unless they're paid?
I think that's ordinarily, and as I understand the operation of the fund and the sub-fund, the Lordship is right, that is how they are redeemed. You make a request for redemption and your shares are redeemed. Of course, in this case, the request for redemption was suspended, and after that we couldn't redeem them. So after that,
I mean, when I think when you first introduced this, you may have said, and I was trying to write it down, that you'd been informed that the shares had been cancelled.
yes. Yep.
Actually,
Sorry.
well, no, I mean, your explanation made at least some sense.
Yes.
Considered redeemed, at least subject to being educated, makes very little sense. Because if your shares had been redeemed in what I would understand to be the conventional way, you wouldn't be here because you'd have your money.
Quite. I expect the answer will be.
Well, you don't spoil the surprise. But anyway, do you have any understanding as to what?
I expect the answer will be that the notice to shareholders at the conclusion of the liquidation said that there were nil assets and therefore the shares had nil value. And I expect it was a redemption. The way it would be said is it was a redemption for nil value. That is what I expect.
But when you say that, where's the letter that is there? Sorry, do we have the document that says that?
My lord, yes, that's.
So somebody had performed a valuation of the fund. That's the point. The terms as to redemption, it's redeemed on payment of a valuation, presumably.
Well,
So I've got, I'm looking at the chronology. On the 11th of December 20,
yeah.
notice to shareholders, board informed investors value of sub-fund is 0, no return to shareholders.
It's divided 30.
30.
In the supplementary.
Yes, it is. Yes. Redemption isn't referred to, but I think the explanation I offered, the likely explanation I offered, is what is being said here on page 331.
It's what, in that first substantive paragraph?
I'm sorry.
In the first substantive paragraph on page 331.
Yes, my lady, and also you'll see reference, third paragraph down, to the calculation of the net asset value of the sub-fund to settle liquidation operations. And then at the foot, final paragraph, as the amount of the liquidation net asset value is 0, no distribution of liquidation proceeds to the shareholders of the sub-fund will occur. Again, the wording is being used in the way.
And I'm always being told that in business and commercial, unlike family, everyone's very precise about their terminology.
I'm not experienced.
Wouldn't dare. I mean, it's just...
So there is a lack of clarity, I think it has to be said.
A lack of precision, because we know who the shareholders are because we've got the Articles of Association, but it would appear that whoever wrote this haven't got them to hand.
Yes, and what you have, surprisingly, and in this final notice as well, as you have, it comes back to the point, you have, apparently they've been trying to market the assets for 3 years. They don't have any joy, so they don't get anything for them. Which, as an explanation, makes absolutely no sense, I would say. May I turn my back for one?
Of course you may. So perhaps ought to read, no distribution of liquidation process to the shareholders of the fund from a sub-fund will occur.
You see, if we were just applying, if I was just applying an English analysis to this, and I appreciate that's always a dangerous thing to do when you're dealing with overseas legal systems. If a company went into, say, voluntary liquidation, and a liquidator was appointed by the shareholders, and the liquidator said, well, I've gone in, I've looked at things, there's nothing there to pay to either creditors or members, that's it.
Mm.
If a creditor who was dissatisfied with that process came to court and said, actually I'm a creditor, or even actually I'm a shareholder, it wouldn't matter. I'm not satisfied with the voluntary winding up. I think there may be assets which have been overlooked or claims against directors. The court could perfectly well make a winding up order by the court of that entity. And that's because the shareholders and the creditors would continue to retain their rights to petition for the winding up. They wouldn't lose their rights as creditors or shareholders just because a process had been gone through which had resulted in no return. What this seems to say is that there's been a process of voluntary liquidation of the sub-fund which has resulted in no money, but it doesn't say that the shares have ceased to exist. It doesn't say the claims of creditors, if there were any, would have ceased to exist had it not been for the settling of the liability, apparently, which is intended to take place. I assume by sub-fund settling its liabilities, it means sort of any sort of trade administration creditors, whatever. But it doesn't say that the shares have ceased to exist. It doesn't show the shares have been redeemed.
The first time we had notice of that point was on Monday.
Yeah.
So, and the effect of that from our point of view is obviously we're prevented from asking questions of the liquidator and getting answers as to what's happened. I mean, it only reinforces, we submit, the need for an independent investigation of this case. And we don't, where we appear to be now, following the information provided on Monday, this really is the only route that appears to be open to us.
Well, you still need to get over ground one.
No, I know that.
But if you're over ground one, then you say the fact that there has been a purported liquidation, or there has been some form of voluntary liquidation of the sub-fund under Luxembourg law shouldn't prevent this court from saying if there's any prospect of return or something which just cries out for an investigation, this court could make a winding up order.
We say that's the purpose of the exceptional jurisdiction in the Russian banks cases, for example. And so, subject always to the point about Section 220, we say it's hard to imagine a more exceptional case in terms of grounds for winding up in this case.
Thank you.
Unless there are any specific questions.
No, thank you very much. You've been most helpful. Now, Simon.
Conscious of the fact that the court has pre-read considerably, and I will try and curtail some of the sort of background material for the court. We did set out in our skeleton argument the sort of course in which these proceedings have developed.
We really don't need to go through that again. We've read it.
But it is material to ground two. I will come back to that. In terms of ground one, as I said, there has been a developing process which we have set out, and I won't go through with the court. I came to court today on the basis that we were faced with it being either a company or an association for the purposes of Section 220.
Well, you don't need to deal with company. We only need to think about association.
Yeah, all I wanted to say about company is if the court is in any way interested in the point, we would say that a company has to be a company incorporated, whether in the UK or abroad. There is one authority which I was going to take the court to.
We don't need it.
But which
Thank you for your
now,
diligence, but we don't need it as it's turned out.
Yes, well, it was the Normandy marketing at 83(8)F, if the court is interested. So we are then in the position here of just looking at the question of association.
Yep.
And Mr. Justice Richard Smith set out relevant case law at paragraphs 19 to 24 of his judgment. But I would like to take the court to one or two of the authorities on the issue briefly, just for a couple of observations. The first one is the very old case of St James's Club, and I'm really going to take the court to one short passage from that. So this is in the authorities bundle, tab 1, page 923 of the report. And he says, though this is middle of the page, that's the sort of the page punch. Though associations are mentioned, I cannot think that word is to be treated without regard to the particulars with its associated. And he said, so I will not say what associations are within the Act, but bearing in mind that the individuals who form a club do not constitute a partnership, nor incur any liability as such. And I just stress nor incur liability as such. I think associations of that nature are not within the Winding Up Acts. He said, at first sight, the word association, whilst we often seem to include in the case of clubs, but looking at the context, and clearly the opinion of it does not. Then, if I can take you and then to the Tin Council case, which is at Divide of 5. And the Lord Justice North giving a judgment of the Court of Appeal. And if we go to page 330, C and to D. He says, in our opinion, Lord St Leonard's decision is of wider effect. Going down to D. In our opinion, the decision establishes a word association is what is now section 660. That's of the 1985 Companies Act.
Sorry, I've lost where you are.
Sorry. This is at just above C. It's just above D, on page 330.
Sorry, got you. Yeah.
In our opinion, the decision establishes a word association what is now section 665 of the 1985 Companies Act does not include an association which Parliament could not reasonably have intended should be subject to the winding up process. Then we go on to the Construction Confederation case, which is at Divide 10.
Do you want us to turn to that?
If your Lordship, you may. And in that case, Judge Pearl considered what he called at paragraph 1 a company known as Construction Confederation, which is an unincorporated association.
Sorry, I'm just struggling. Sorry, it was my fault. I was just trying to remember the context of that comment in ITC. Sorry, where did you take us?
Sorry, just if it's the first, it's Divided 10. It's the first first page of the actual judgment.
Yeah.
He said a present association is a substantial commercial organisation which has conducted business on a large scale. And he says, looking at the wording of the statute, the word association could hardly be wider and is on the face of it apt to apply to the present institution. However, Mr. Arden QC drew my attention to a number of authorities which might suggest otherwise, including ITC, and he says, it is clear from that case but not every unincorporated association is an association within the meaning of what is now Section 220. And the question was, could Parliament reasonably have intended that the ITC should be subject to the winding up process of the English UK insolvency legislation?
Yeah, the reason that it wasn't held susceptible to being wound up by the English court, I suggest, had nothing to do with its structure or characteristics, except for the fact that it was a body set up between sovereign states by an international treaty. I mean, that's why the court said it's not the type of association that can be wound up by an English court. I mean, yes. If you just ask the question, is it an association between members of something which holds property? The answer is yes. So in the raw sense, it's an association, but it's not an association of the type the English court should interfere with, because of the nature of the members and the nature of the contract by which it was established. So, I mean, it undoubtedly was an association in the very broad sense,
yes.
His Honour Judge Pearl would have contemplated, but it's just the nature of the beast, the nature of the people who constitute it and how it's put together, that means the English court should just say hands off.
Yes, there were particular factors at play in the ITC case, but I get what I'm trying to sort of draw out of this is that the word association in general life has a particular, maybe quite wide definition, but when we look at it for the purpose of Section 220, there's a narrowing.
But the narrowing that was in play in ITC is not in play in the instant case, is it?
Not specifically. No, there were wider and separate, different considerations.
Yeah.
Yes.
Well,
But-
Mr. Lewis would say it fell foul of his third limb.
Yes. Well, what we say is this: how is it that Judge Pearl approached it in this
Right.
case? And that's why I'm taking to ITC, because here's a practical application of how the court applies the test. He looked at St James's Club, and he points out, for example, at the end of paragraph 4, Mrs. Lord St Helens seemed to envisage that the position might be different if the members were liable as such for the debts of the club. And then he turns to Justice Morritt in the Whitney Town case.
Faint hint of disbelief in the Lord Chancellor contemplating that a gentleman's club could be wound up. I mean,
Yes.
perhaps might not be quite so worried about it these days.
Well, I think my lord also, he talked about cricket clubs.
I'm sure they'd be susceptible as well.
But anyway, Mr. Justice Morritt in the Whitney Town case, again, Judge Pearl points out that Mr. Justice Morritt noted that members were not liable beyond their subscriptions. And he says in paragraph 6 that each case must turn on its own facts. And he looks at the particular provisions here, and he says, among other things, at the bottom of the paragraph 6, most importantly, the members undertake to abide by the provisions of the rules of the Constitution, and most importantly, acknowledge an obligation to pay such sums towards the liabilities that might be determined in accordance with a particular rule and appendix. Thus, this is not, in the case of an ordinary members' club, an organisation that one joins simply for the purpose of recreation and pleasure in return for an annual subscription. The rules clearly envisage that members may become liable as such to contribute to the liabilities. And then, having conducted that analysis, he then says, CC does seem to me to be the sort of organisation which one would expect in the event of insolvency to be within the contemplation of Parliament in 1986 when re-enacting provisions going back to the 19th century extending the winding up jurisdiction to unregistered companies by reference to the concept of an association. So that's the exercise which was carried out by Judge Pearl.
So what difference does it make that it was non-profit making? As identified in paragraph 6.
The part I'm particularly focused on in the analysis is that an important element seems to be whether members are liable. There's a potential liability of members on the winding up.
Yes, but that's because if members are potentially liable on the winding up, and the winding up is being bought for the benefit of creditors, then there's something in it for the creditors. You know, so if a creditor says, look, that members club owes me money, the court would say, well, okay, well, we'll wind it up because on the winding up, the members are liable to contribute to pay the debts of the creditors. It's a collective process for creditors. Similarly, if you have, let's say, no external creditors, but you have property held by the association, and a member comes along and says, look, this organisation is not doing anything anymore, it's just sitting here. It's come to the end of its life, but it's sitting on some property which is due to be distributed to the members after making sure all the creditors are paid. Please, will you wind it up? Then the court would probably say yes. If, however, you had an association that didn't exist either to take in, to incur liabilities or to own property, but was just an interest group, shall we say, then the court might say, well, what's the point? You know, it's not the sort of association we should wind up because it's got no creditors and there's no property to distribute. So what, you know, in fact, as Mr. Lewis said, you know, what does winding up even mean in those circumstances? So isn't the question of whether you're conducting business with a view to profit or holding property really just a step in a reasoning that says, is there some purpose to actually putting somebody in charge of this entity to quote, wind up its affairs?
would endorse that with the caveat that we're looking at a type of entity rather than a specific, necessarily a particular situation in which that entity finds itself in, which would be.
Yeah, but if you have an entity which takes in, if you have sorry, we don't use the word entity. If we have something, and I don't by that mean it has to be a legal entity, but if we have an association that collects in large amounts of money from members, shareholders, for some collective purpose, then why shouldn't it be susceptible to be wound up if it's either not paying its creditors or if its purpose has come to an end, in order to achieve a payment of creditors and a distribution of any surplus to its members?
Well, I guess the question, applying it to this case, the question is if there is an entity that court could wind up under Section 220, why would it be the sub-fund rather than the fund itself?
Yeah, well, that's a different question. But if what is here fits the concept of, quote, an association, and that's where I really wanted to push you a little bit, then you've got something which held a large amount of money, which it took by way of subscription from its shareholders, members. On the face of it, why would it be an association that was not susceptible to be wound up, if it's quotes an association at all?
Depending on which, well, I suppose what I'm looking at is which are we talking about? The fund, if it wasn't a company, it would be an association. The problem is we don't accept the starting position that the sub fund itself
Is an
association,
well,
or indeed has.
That's where you really need to go, I think, because
Yeah.
if you could explain why you don't accept
Yes.
that the sub fund is an association.
Yes.
What is it in the structure of the sub fund that makes it not an association?
Might it be helpful if I start with the issue of liquidation, which my learned friend spent some time on, or if you would prefer, I look at it more widely.
Well, take your own course, but I think we're all interested because ground one is critical.
Yes.
To the appeal itself, to question one, was
Yes.
the sub-fund an association?
I wonder if I could
It's
just.
clear the judge
Yeah.
thought not, so they've
Yes.
got to show that that was wrong. But we'd like to know why you say the judge was right and what you
Yes.
base your submissions on to say that the sub-fund was not an association.
Yes. I wonder if I could, while we have the authorities, if I could just quickly take you to Whitney Town. There is one point on that which, before we move away from the law, the Whitney Town case is Divider 6. And I just want to take the court to 489 at from G onwards.
Would you like us to read that?
If you just read,
We'll read the sideline passage, shall we?
Yes, I'm grateful.
Certainly.
Well, this passage is contained in both skeleton arguments, is it not? We have all read it.
Yes, the first point is the word, my learned friend put a lot of focus on the word any in section 220, and I just really want to point out that he says, for example, paragraph 42 of his skeleton, the breadth of section 220 is further emphasised the words any association and any company, and a similar assertion is made at paragraph 45. I'm simply pointing out that, as Mr. Justice Morritt pointed out, that is not a fair way to construe Section 220, the apparently unlimited word "any" cannot be given its literal meaning. And again, at 491, one of the other factors that Ms. Justice Morritt referred to is said that plain the members did not constitute a partnership, nor under rules did they incur any liability for members except for their subscriptions. One of the tricky things.
I mean, this is a case in which a social and recreational club the rules, the Constitution did not impose any liability on members to contribute to the assets or pay the liabilities on a winding up, and neither would they benefit from the distribution of any assets. Yes. So is it that surprising that he said, well, I can't really see why Parliament would have thought it would be appropriate to wind this type of thing up as an association? He wasn't saying it's not conceptually an association.
Yes.
In a sense it plainly is. But it's just not an association that the Parliament would have thought that you should apply Section 222, because just what's the purpose?
Well, the way in which the courts below considered the issue of, for example, the issue of contributories, was that was a matter which went to the question of whether or not the thing was an association for the purposes of Section 220. And,
Could be.
For example, if the Deputy ICC Judge said at 42 that
Paragraph 42.
Paragraph 42, page 107.
Yep.
The sub-fund has no contributories, although the insolvency legislation clearly envisages the existence of contributories. And the relevant sections of the Insolvency Act are in the supplemental bundle, which was handed up today. And I wonder if I could just briefly take court to that. It's at the...
Yes, for those of us that it's not their specialist field, it would be very useful to have the relevant sections in the first version of the supplementary bundle we get.
I entirely agree, and it is unfortunate that that wasn't done.
Luckily, I haven't.
And I take, to the extent necessary, responsibility for that.
But it's not unique, actually. There's another case I've sat on where people took a look at the Court of Appeal rules.
We sat on it together.
We did. Okay, there we go. The strict reading of the rules, of the Court of Appeal, what is it, the practice guide, would suggest that you don't put the relevant pieces of legislation into the bundle of authorities.
If it's agreed. If it's agreed that that's the relevant
Well, what we've done is...
But anyway, we've got it. In
Divide
any
and
event, it was fine because I printed it out so that I had it to hand when I was reading the judgment.
I'm grateful. So Divider 8 has the relevant parts of insolvency, including all of Part 5, because it was felt Part 5 is a self-contained small group of sections, and it's appropriate to see how Section 220 and 221 fit.
You want us to look at 226 contributories.
If we go to Section 2211, just to trace it through, 2211 says, subject to provisions of this part, that is Part 5, any unregistered company may be wound up under this Act, and all the provisions of this Act about winding up apply to an unregistered company, with the exceptions and additions mentioned following subsections which are not material. Section 2291, which is, that was at page 72 of the new bundle. Page 77, which is section 229, provides provisions of this part with respect to unregistered companies are in addition to and not in restriction of any provisions in part 4 with respect to winding up companies by the court. Incidentally, that is why the locus standi requirements in section 124 of the Insolvency Act in part 4 apply to part 5. So locus standi at Section 124 applies to sections 220 and following because of Section 229. So that means that Part 4 applies. Now, Section 74 is at page 65, at the beginning of Part 4. It says there, when a company is wound up, every present and past member is liable to contribute to its assets to any amount sufficient for payment of its debts and liabilities and expenses of winding up and for adjustment of the rights of the contributors among themselves. And it's subject to certain provisions, exceptions in subparagraph 2. Now, the word, if you go on to section 251, which is at page 79, in this group of parts, contributory has the meaning given by section 79. And finally, then, if we go on to section 79, which is page 68, contributory is defined as every person liable to contribute to the assets of the company in the event of it being wound up, and for purpose of all proceedings for determining, etc., the persons who are deemed to be contributories, include any person alleged to be a contributory. And section 226, if we go back to the part relevant to this appeal, provides headed contributories and winding up of unregistered company. In the event of an unregistered company being wound up, every person is deemed a contributory who is liable to pay or contribute to the payment of any debt or liability.
You read it differently. It's every person is deemed a contributory who is liable to pay or contribute to the payment of etc., etc., etc. I mean, you can wind up an unregistered company even if you don't have contributories. I mean, if what the submission is that you have to have contributories to constitute an unregistered company, that's got to be wrong.
I'm not suggesting that, but what I am suggesting is as both the Deputy ICC Judge and Justice Richard Smith considered, it is a material issue to the question whether the sub-fund constitutes an association, which Parliament could reasonably have intended should be subject to a winding up process. And
when looking at characteristics,
yes,
they're not a contributor, so therefore that focuses away from it being an association.
yes, and we say it's not a sine qua non of being an association for purposes of the Act, or of more particularly Section 220, but it is a matter of some materiality to that question. It was considered so by both courts. The Deputy ICC Judge Kyriakides at paragraph 44 of her judgment, and Mr. Justice Richard Smith at paragraph 41 of his. The references are page 108 to 109 and pages 76 of the core bundle.
Do you say that points away from it being an association at all, or do you say it points away from being an association which Parliament could have intended should be wound up?
An association for the purposes of within the ambit of Section 220.
Yeah, but that's not actually an answer to my question.
Perhaps I could.
So let me give it again.
Yes.
Do you say that the absence of contributories means that the thing is not an association at all, or do you just say it's not an association which Parliament could have intended that Section 220, whatever, should apply to?
Of the latter, my lord.
Right.
Because there's a narrowing, as I suggested.
Yeah.
I'm not suggesting that it's a sine qua non of an association in a wider sense. But when we're looking at the second question that your lordship identified, it is material.
But don't you think it's material for both? I think your junior does.
It may be material for both. I haven't come today to try and give it a definition of association in general life. It's extremely it's not a sort of clear. One of the things that the courts have done.
Suppose you have a club which, by its constitution, says the members shall not be liable to contribute to the liabilities of the club. But the club owns a lot of property because members pay subscriptions and they go out and they buy a cricket pitch. Okay. But the club then just doesn't pay its debts. There's no reason at all why that club shouldn't be wound up. The fact that members aren't liable doesn't mean that creditors wouldn't benefit from a winding up, because the pitch would be sold and the proceeds used to pay its debts. So I don't see that the absence of a contributory, or the absence of contributories, does much other than perhaps to go to the question of whether there's any purpose in winding up, i.e. is it the sort of association that might be capable, that should be wound up? That's at the moment the way I'd sort of look at it.
Well, that may be a way you look at it, but in this particular case, it's just one incident of the fact that, as Mr. Justice Richard Smith pointed out, in paragraph 63 of his judgment, he said there was much to be said, in my view, for the respondent's submission that the appellant prays in aid characteristics of the fund to elevate the sub-fund to a status it doesn't enjoy in its own right. And that, we say, is key to a lot of this in this case. And the fact, now, for example, the skeleton argument of my learned friend refers to paragraph 50 to, among the sort of features of a company, of the entity, is said to be the fact that there are, it talks about the purchase of shares in a sub-fund and shareholders in a sub-fund. These are shares and shareholders in the fund itself. And so similarly, they're not maybe it's one of those factors that they're not contributors of the sub-fund. But the fact is there is another entity here, which makes this case very different from other cases where there might be a club that buys a cricket ground or pitch. There is actually an entity here, which is, as you know, would be the more logical subject of a petition. And what the petitioner is seeking to do is to try to sort of get the court to creatively develop the law to where there was it was a member of a fund, but chose to present a winding up petition in respect of a sub-fund. And that's where we're having these sort of slightly convoluted and theoretical discussions, where in fact they've just gone against the wrong target.
And that's the point you make in your skeleton argument. Can we come back to the question my lady asked some 10 minutes or so ago, which was admirably focused, which goes to ground one, what do you say are the characteristics or not the characteristics of an association in respect of the sub-fund? Now, you've dealt with contributories. What else?
Well, perhaps I could now, if I could summarise really, we're following what Deputy ICC Judge noted, and that's summarised in our skeleton argument for the appeal. I'm grateful for the focus. And that is, they were summarised at paragraph 33 of our skeleton, which is page 10. The first one was a contributories point, and I won't say any more about that. Second is, the sub-fund cannot itself create legal rights or incur legal obligations and liabilities. Thirdly, it has no board of directors or management committee. Fourthly, it doesn't itself own any assets, nor is it liable in the legal sense for any debts or other liabilities.
Sorry, I'm
Page 43, it's the skeleton argument.
yeah, that's where
Paragraph 33.
I'm looking.
Page 44, it started on page 43.
I'm sorry, yes, I've got you now, sorry. Yep.
So there are 5 matters set out here. One is contributories, one is can't create legal relations or incur legal obligations and liabilities. No board of directors or management committee. Doesn't own assets, not liable in the legal sense for any debts or other liabilities. It can't sue in its own name.
I suppose what you're saying in a way is you've got, going back to your fund point, you've got the fund, that's your association.
Yes.
That's capable under 220 of being wound up. You can't then start saying that because they've got, little jars along the mantelpiece,
Yes.
which they are the sub-funds, that you suddenly say that the sub-fund under the umbrella of the fund is in its own right an association, which fits within the criteria of section 220.
Indeed, my lady. I think I tried to say at the beginning, and maybe I should repeat it. Is the as Mr. Justice Richard Smith said at Para 65 of his judgment, I quoted at Para 37 of the skeleton. In substance, the sub-fund was a portfolio of assets comprised within the umbrella structure of a fund. And he then said it's clear that they were not shareholder members, sub-fund, no shareholder fund, but it's a portfolio of assets. And
Yep.
the paragraph 33 sets out sort of some of the key findings of or determinations of the ICC judge. There's also the RT regulations, which were relied upon initially by the...
Just before you go to the RT, can I just pick up both my lady's points actually? If you ask the question, what does association mean? It means a sort of coming together of persons.
Yes.
And conventionally, you'd say the coming together is done in a way that's governed by some sort of arrangement. And for a club or association, it's the members agree to the rules. And if it's a company, it's the shareholders are bound by the articles. And you say the shareholders in this case were bound by the articles of the fund. They associate together with respect to the fund. I think you say they don't associate together with respect to the jar on the mantelpiece.
Yes.
They have an interest in relation to the jar on the mantelpiece, but that's not the association that they've entered into. The association is their membership of the fund. That's the key difference, isn't it?
It is
between you and Mr. Lewis.
It's I think, my lord, it's a bit like the sort of analogy that your lordship was connected between sort of A-class shareholders, B-class and C-class shareholders. There's shareholders in a fund or a company. It's just they have different classes of share.
Yeah, and their association is with the other members of the company and their class, but they don't associate with the assets which underpin their investment, because those assets belong to the fund and they're kept in separate jars on the mantelpiece.
Yes,
But they're
portfolios of
not
assets.
associating. You say that they're not associating together by any legal mechanism with the assets.
My lord, you put it much more clearly and better than I have. But my lord, I would adopt that analysis. And that's one of the tricky things, and I think why the courts before were looking at it, we were trying to get a handle on such a novel and bold argument, because there's a logical, there are shareholders in the fund here, and so looking at little aspects or jars of assets just didn't fit in with the actual underlying reality of the situation of them being shareholders in a fund, the fund owning the assets, the fund having the board of directors, the fund being able to sue, and my learned friends had recourse to some idea of somehow lending the name or some form of device in order to try and bring themselves within the ambit of this legislation, when plainly it's not suited to it. We've set out in the skeleton argument a further analysis of the relevant issues. There is, and also the analysis by Mr. Justice Richard Smith,
Yes.
which I won't repeat. The only point which it seemed might be helpful if I said a bit more about the liquidation point, because that was seen as, I think, the strongest point or the point which greatest reliance was thought to be placed by my learned friend. And that's not something which I think has been considered in any detail specifically. I wonder if that would assist. The argument put is that the both judges gave insufficient weight to the features of the sub-fund, that it could be liquidated voluntarily under Article 76(1) of the Luxembourg law, independently of a fund, and it could be liquidated judicially, independently of a fund, under certain conditions under Article 47(1) of the Luxembourg law of 2007. And so it argues, paragraph 52 of the skeleton for the appeal, the appellant, but if the sub-fund was capable of being wound up as a separate entity in Luxembourg, there was nothing to suggest it could not be wound up by the English court as a separate entity. Now, if I can first of all take your report to the evidence of Vanden Bulk on this.
Sorry, of?
Vanden Bulk, I may not have pronounced correctly. It's that the sort of supplemental bundle, page 101. And the question asked, first question is the dedicated fund a legal entity as a matter of Luxembourg law? And now this is page 101, my lord, divider 13. Is the dedicated fund a legal entity as a matter of Luxembourg law? The question is related to the concept of dedicated fund, also denominated sub-fund or compartment. The fund is a so-called umbrella fund constituted with multiple dedicated funds. A dedicated fund is defined in the offering document as a separate portfolio of assets within the fund. According to Article 71(1) of the law of 2007, specialised investment funds may be constituted with multiple compartments, each compartment corresponding to a distinct part of the assets and liabilities of a specialised investment fund. Therefore, the sub-fund corresponds to what the law of 2007 defines as a compartment, being a distinct part of assets and liabilities. A compartment consists of a pool of assets and umbrella structure. And paragraph 5.1, further on, Vanderbilt reports that each compartment is treated as a separate entity. You'll see second last paragraph of the page. However, separate entity does not mean a separate legal entity. Indeed, the fact that each compartment will be treated as a separate entity does not mean that a compartment is a legal entity by itself. A legal entity is commonly defined as an individual, company, or organisation that has legal rights and obligations. A legal entity has legal existence and the capacity to act independently through its own statutory bodies. A legal person holds rights which allow it to carry out its activities. On the contrary, a compartment has no legal personality, and as such, no agreement may be signed by, nor can any action be brought against a compartment in isolation. A compartment consists only of a pool of assets, part of an umbrella structure. An umbrella fund is a collective investment vehicle that exists as a single legal entity but has several different compartments or sub-funds. That is a backdrop to the issues I'm going to address, which are the question of voluntary liquidation. Now, that is addressed by Vanden Bulk at page 104 here. Page 103, I should say, is the question at 5.2 is, can a dedicated fund be bound up under Luxembourg law other than by the board of a fund under Article 16? And it says bankruptcy is the only procedure used exclusively to wind up insolvency companies, but it's not available. Against a company having a legal personality, you don't contemplate the insolvency of a compartment of an umbrella structure. The insolvent compartment of an umbrella structure, which has no legal personality, cannot be subject to bankruptcy. As such, the only procedures available for an orderly liquidation compartment would be voluntary liquidation or judicial liquidation. Just pausing there, my lord, we've got a situation here where, under Luxembourg law, the sub-fund could not be subject to bankruptcy. And yet, that is what is being sought to be ordered against the sub-fund here. Secondly, voluntary liquidation. Voluntary liquidation of a compartment is permitted under Article 71(6) of the 2007 law, which provides a specific provision here. Each compartment of a specialised investment fund may be liquidated separately without that separate liquidation resulting in liquidation of another compartment. Voluntary liquidation is decided by Board of Directors of a specialised investment fund in accordance with its articles and so on. And now, Article 71(6) of the law expressly permits voluntary liquidation of a sub-fund. That is, but there's then this is a contractual and administrative exercise permitted, in this case, by Article 16(G) of the Articles, which you were taken to before. And now, Deputy ICC Judge Kyriakides considered this, and in paragraph 57 of her judgment, which is page 114, she says that the voluntary winding up provisions don't themselves show it's an entity within section 221. And that is agreed with by Mr. Justice Richard Smith at paragraph 57 of his judgment, which is at page 80. It says unremarkable. It says unremarkably, the fund has the power to liquidate assets within a dedicated fund and distribute them to the relevant investors and creditors. So that's page 80. That's paragraph 57 of Mr. Justice Richard Smith. So what we say is we support the findings of both courts, and we say it doesn't itself mean that it's in any way a positive indication, a positive characteristic that should lead the court to consider that Section 220 applies to the sub-fund. On judicial winding up, that's also dealt with by Van der Balk at page 104, and talks about the law of 2007. It says, according to Article 47(1) of the law of 2007, the district court dealing with commercial matters shall, at request of a public prosecutor, acting on its own initiative or at request of the CSSF, pronounce for dissolution and order liquidation of one or more compartments of a specialised investment fund, subject to law, in cases where the authorisation of these compartments has definitely been refused or withdrawn. And Article 71.7 says the authorisation of a compartment are subject to the condition that all legal, regulatory and contractual provisions relating to its organisation and operation are complied with. And says, can it be wound up under the law of Luxembourg by court order? A compartment, this is at page 105, a compartment can be wound up by the court order through a judicial liquidation procedure, however, in only specific cases, namely when the authorisation of a compartment has definitely been refused or withdrawn by the CSSF. So judicial liquidation is possible, among other things, on specific cases, being the authorisation of a compartment has definitely been refused or withdrawn by the CSSF, who may decide it on the basis of a breach of any legal, regulatory or contractual provisions relating to the organisation and operation of the compartment. Taking into account the interests of investors and all the circumstances of the case, including, among others, the insolvency of a compartment. And the law provides for no other means of winding up the compartment. That's at the bottom of that page. So what we say is that it seems to be that the provisions of the Luxembourg law of 2007 provide the teeth to regulatory oversight by the CSSF and in extreme circumstances the Luxembourg District Court. In circumstances where there's been misconduct, breach of any law, regulatory or contractual provisions relating to the organisation and operation of the compartment, and authorisation has been refused or withdrawn. What we say is that the power to dissolve and liquidate a sub-fund in these circumstances, to wind up a sub-fund in that circumstance, is not a winding up in a classic sense, but a narrow protective measure open to regulators and the court in circumstances of misconduct. And what we say then is the fact there's a regulatory scheme available in these particular circumstances, in circumstances where, as I said before, the bankruptcy is not available in general, does not support a finding that this is an indication, let alone any strong indication, that Section 220 should apply to this sub-fund.
So does that conclude ground one?
That concludes ground one, yes. I'm conscious of time. I don't know whether...
Well, would you prefer to do ground two after the short adjournment?
It might be a wee bit quicker, yes.
I don't anticipate... How much... I'm not putting any pressure of time on you, but how long do you anticipate being for grounds 2 and 3?
Ground two should not be... there should not be much to say about that.
No.
Ground three could be a little bit longer because it is potentially quite significant legally if that issue is going to be looked into further. There's also an issue about whether it's open to the appellant to rely upon the dissolution of the fund in circumstances where that hasn't been its pleaded ground, one of its pleaded grounds of petitioning. The section applies to dissolution or cessation of business and so on, but they hadn't. That's not how the case has ever been put.
If that's in the Court of Appeal. Okay.
Well, the point is this: it's never been put as a dissolution case. In fact, below it was expressly said not to be a dissolution. They weren't relying on dissolution. Now, because of the Russian cases, that is now, from a supplemental skeleton, seems to be a ground of...
in response to your respondent's notice?
Yes, but we say that that's... Well, I won't take a lot of time up on that point if it's seen as not worthy, but it is important that it expressly wasn't put on that basis below. And indeed, Lexa Hilliard, KC, specifically said we are not seeking it on that basis. So it's a slightly stronger position than normal.
Very well. 2 o'clock, please. Thank you all.